Great. Looks like it's just about 1 o'clock, but looks like people are still trickling in. Maybe we'll give it 1 more minute. Should we go ahead and get started? Great. Nadine, I will let you kick it off.
Great, thanks. Thanks, Jeremy. We'll see if we get a few more people coming in here.
Sorry, I just joined.
Hello, welcome. Thanks. Thanks to all of you for coming to the second meeting for this recommendation. We have a lot of work we want to try to get done here. I will try to plan for a break at some point in it when there's a good moment, hopefully about halfway through. I know, as I said last time, Zoom fatigue is real and we don't want to exhaust anybody unnecessarily. So do you want to do the roll first, Jeremy, or yeah, okay.
Yeah, let's do that. So I will read 2 roles. The first will be members of the committee. Please just say here after you hear your name, just so we can make sure your microphone is working. In the second list, I will read ACUS members who are not members of the committee. I will not read members of the public who do not have speaking privileges. So starting with committee members, Kent Barnett.
Here.
Jack Bierman. Eric Benderson. Michael Cole.
Here.
Anika Cooper. David Engstrom. Claire Evans. Kai Feldblum.
Here.
Susan Sui Grunman. Janice Hoffman.
Here.
Renee Landers. Tristan Levitt.
Here.
Richard Layton. Robert Lesnick. Jeffrey Lubbers. Alexander Manuel.
Here.
Thomas McCarthy. Melissa McIntosh or Kareth Cohen. Patrick Nagel. Roxanne Rothschild. Robert Schiff. John Vitone. Chris Walker.
Here.
David Welch. And Russell Wheeler. I think I see you, Russell, but I'm not sure I heard you. I remember we had audio issues last time. Uh-oh.
Yeah.
You might have the same audio issue as last time.
Oh.
He'll try.
He'll try again.
Yep, exactly. And then from other committees, but from ACUS, Bill Funk.
Here.
Great. I think that's it. Back to you, Nadine.
Great. Matt, did you have any comments or
Just
wisdom?
to thank everyone for hanging in with this project. I think the debate on this, the discussions on this project have been, or draft recommendation have really been exemplary. And that's in large part to your leadership, Nadine. And I'd just also like to thank Fred once more. It's very evident from the discussions and from his report that he has real and in some ways unparalleled expertise in this area, and the conference is very fortunate to have him. And finally, I just want to thank, I know we have some members of the public who are watching or participating in the proceedings through the submission of comments, and I'd like to thank them as well. So that's it, Nadine. I just turn it back over to you, and think we'll have a good meeting today.
Great, thanks, Matt. As I did last time, we're going to cover a few ground rules before we dig in. I know we have a lot of work we want to get done today, hopefully, and not have to have another meeting. So the ground rules, please remember that only ACUS members, which includes government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates, have full speaking privileges. Please keep your microphone on mute so we can minimize background noise, and use the hand raise feature or add a comment in the chat feature if you'd like to speak. I will call on you and you can unmute, say your piece, and then remute when you're done. I ask that ACUS members and their alternates please use the webcam so that we can see you. Find that that works best for these meetings. And then with respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. So time permitting, I will consider calling on such attendees at appropriate points. And we will presume that the committee members consent to that, absent their raising an objection. If any such participant would like to speak, please indicate in the chat feature or use the hand raise function and wait to speak until I call on you. You can unmute and then remute when you're done. For all participants, please use the chat function only to indicate that you would like to speak or to vote when we get to that point. Please do not hold sidebar discussions or put substantive comments in the chat feature. When we get to voting, only members of the Adjudication Committee have a vote. Please do not vote unless you're a member of the committee, and Jeremy and I have a list of the members in case you're not sure of your status. So with that covers our ground rules. Let us turn to the revised draft, which I hope all of you have had an opportunity to look at. There we go. And based on our discussions and deliberations at the last meeting, some changes have been made both to the preamble and to the part of the recommendation that we've already discussed. There is a part of the recommendation that we have not yet discussed, and I want to be sure we get to that. But before we get to that, let's look at the preamble. I'm going to just take it all as one fell swoop. If there are things that in the preamble that have been revised that you're interested in discussing or making a comment on, now is the time to do it. There's been changes to this first page. We can kind of take it that way. First page, I think there's some on the second page. So each page has its own set of revisions. Are there any comments on this first page? Great, can you accept as we go? That's great. Good idea, Jeremy. So then the second page. This is where we've made an adjustment based on our discussion about what it means to have a traditional video hearing and virtual hearings, and that virtual hearings can have different components to them. I did notice that in the changes that were made on lines 32 to 35, there's some redundancy now with lines 36 to 38. I think that could be easily adjusted by possibly just saying this recommendation uses the term virtual hearing to mean such proceedings or something like that. And then we wouldn't need all of the description because we already have it. But any thoughts on this part? I see Bill's hand raised. Bill.
My only comment, and if you strike that that language that's now in blue, that would take care of it. I would want to get their personal devices. I want to strike the word "their" because it might not be their personal device. It might be their attorneys or someone else's that they were using because they didn't have it themselves. But if you take it off, that takes care of that problem. Thank you.
Any other comments on this part? I didn't know, I was just gonna raise too, I didn't know if there was a benefit to citing to Jeremy's report here. I know we do that on the next page. I'll leave that to, I guess, maybe the Committee on Style, if there's a possibility that it might fit here to kind of explain some of the parameters of the type of hearings we're thinking about here. That was one thought I had there, but other than that,
You're thinking right here, Nadine, line 39. Great.
and I think we can accept those changes as well.
Great.
Okay, next page. We had a comment that I hope you all have had a chance to review. It's very thoughtful comments about the recommendation as a whole. And this is one point where I think a comment has been raised by Legal Services New York and the Empire Justice Center. And some of their concerns relate to concepts we've discussed, that we discussed at the last meeting. And I appreciate Jeremy flagging this here. If you've had a chance to look at it and you have any thoughts about changes that could be made here that might take some of these concerns into account, I'm happy to hear it. Bill, I see your hand is raised. So we'll start with Bill and then Russell.
Well, actually, it was left over from last time, but I forgot to take it down. But I think it's okay here because it says often as opposed to always. And so, and later we do talk about the fact that some people can't have this equipment, and we need to take account of that. So I think this language here is all right. I mean, I gave real thought to the legal services memo, but I think it's okay here at this line.
Thank you. Russell, I hope we can hear you.
Can you hear me?
Yes, excellent.
Well, I at the same point on line 54 after as well, we could, this is in light of the comments from the public interest lawyers, something along the lines of pose challenges as well, comma, beyond the fact that some participants do not have or have any minimally acceptable equipment, something like that.
Maybe we say some participants may lack.
Anyway,
no.
I just thought this was a place you might take their well-taken concerns into consideration.
Okay, and then I saw Jack, and then we'll go to Hi. So Jack first.
Okay, great. So, and I think that phrasing is a little awkward, the one that's still highlighted right now, because the individuals often own the equipment and then participants can often appear. How about something like, because individuals either own or can access the equipment needed to participate in virtual hearings, participants may be able to appear from their home or an attorney's office. How does that sound?
That sounds good to me. Any further thoughts? Hi.
And then on 55.
Hold on.
Sorry.
No. Go ahead, Bill.
And then on 55, I would add lack, instead of lack suitable equipment, I would say lack access to suitable equipment. Because that would encompass either them owning it or borrowing it from their attorney or some other friend or whatever.
Thanks, Jack. All right, Hi, you were next.
Well, actually, I like those changes. We've now taken out often, either own or can access. I really did like the comments that were made. I think generally they were made in that letter, and I think they were right on. I think generally below we have dealt with some of them. I think it may be worth, even though I don't love footnotes, putting in a footnote at the end here. And by the way, to go back to often, because individuals often either own or can access. Right, often either own or can access, may be able to appear, and then footnote, that is not the case for all individuals which we address below, something like that,
Mhm.
An issue that we address below, because the topic sentence for this paragraph is virtual hearings can offer civil benefits. So here's the benefits. And I think the footnote is simply, it's saying to them, we heard you about these lines. And, so there's a pin for it in the footnote. They simplify schedulings, that then, because in the next one, 55, by virtual hearings can pose challenges as well, beyond the fact that some participants, that's good. Although of course that hasn't been said in text beyond the fact, other than through the word often. But I think I'm fine with that. I mean, if we put in the footnote, we will have referenced it at least in the footnote,
Mhm.
and it's at least implicit in the often. So the truth is, I feel like we addressed a lot of their issues already in our discussion in the last meeting, but this, I think, just carries the utility of saying directly to them, yes, we heard you, see these changes.
Okay. Roxanne, I think you're next.
Hi, yeah, I was thinking that with regard to lines 46 and 47, I don't think we even need the first half of that sentence at all. I think that we could start with a capital P for participants and just say participants and save the word often, because Kai likes it. We could say participants may often be able to appear from their home, and then add after home using their own personal equipment. And then it just goes from there, or an attorney's office. And then we keep the footnote that Kai suggested. So basically, you're making the point, which is virtual hearings have many benefits. They could use their own equipment or go to an attorney's office and not have to travel somewhere, recognizing that not everyone can do this.
Russell.
Well, my only suggestion is, rather than a footnote, just make it parenthetical. Why make readers go, this is an important point. Why not just put it in a parenthetical rather than a footnote? Make it easier on the readers.
Okay. And Fred.
In line 48, you may want to, just for accuracy, add or other location. We have had discussion about library use originating from public libraries and other locations.
I think that's consistent with what we said. Mhm. Okay. Jack.
Okay, so, I hate to be a stickler for language, but I always am. I don't understand what the word often is doing in that sentence, since we already say may. I mean, may means some can and some can't. I don't, the word often just sticks out. Like if I was writing this, I wouldn't include the word often. Participants may be able to appear from their home using their own personal equipment or an attorney's office or another location without the need to travel. I mean, I don't know what the word often does in that sentence. If it's may, because may implies that some may not.
Mhm.
Yeah, and this is high. I'm fine with taking that out, especially once we have this in the parenthetical. They may be able, this is not the case. I mean, I know that's a repeat then of the may, but I think it gets the point. So I'm fine with not having often. I agree.
And the parenthetical instead of the footnote.
Mhm.
Okay. Russell, did you have another point?
Oh, no. Well,
Okay.
it should be an issue that we address below, but that's minor.
Great. I actually think Roxanne's suggestion about deleting that opening clause I think that was the part that the comments were most concerned about, that the suggestion that this is a, normal thing. Of course they have them. Okay. Any other thoughts on this page, the edits that we've just made? Anything further? We'll have to keep those in mind because I think we come up with There may be other points later in the recommendation, in the recommendations themselves that we might have to reconcile with what we just did, but. Next page, 61 down. There's some added text there regarding recordings, which we discussed last time. Jack, do you have another point? No, okay. I'm not seeing any hands. I had one thought at the very end of the recording paragraph. I didn't know if observation was the word to use there, or access. If the idea is that we're making them available for them to access, obviously they're going to observe it. It's a video, right? Any other thoughts on that? Wonderful. Oh, I see a hand. And it is Professor Landers.
Thank you. One question I'm wondering, are we assuming that the state laws that might relate to recording conversations are inapplicable because of preemption, of federal preemption in this set of circumstances? Or is that something that we should flag because there are some, pretty particular requirements about authorization and consent to recordings in some states? Jack maybe has the answer to this question.
Jack, do you have the answer? Otherwise, I'm going to flip it to Jeremy to give us some insight if he has.
I'm currently tangentially involved in litigation before the Supreme Judicial Court on the two-party consent requirement in Massachusetts. But maybe inserting somewhere that agencies may need to consider whether, I don't know. My answer is I don't know whether a federal hearing is subject to rules. Like in Massachusetts, you need two-party consent, but it also is required that the recording be in secret. So if you announce that you're recording, you're in compliance with the with Massachusetts law, unless my side loses the case we have pending in the Supreme Judicial Court right now. Because there you have a person who was tricked into allowing the recording, but he knew the recording was going on, and he's suing, claiming it was a secret recording.
So, the only thing I would say about that is that every person, your institution and mine both go to elaborate lengths to get people to sign the releases and authorizations to, I don't know if it's just an abundance of caution, but, it's very clear that many of these programs that our institutions run are going to be recorded, and then we're going to put everything on the website and all this other stuff. So I just, I'm not sure how far that gets you, but there may be a preemption rule that makes this irrelevant.
Yeah, I don't know the answer. I had a different issue on this paragraph, but.
Jeremy, did you have any thoughts on this? I don't. Yeah, go ahead.
In particular, Fred, did this come up in any of your interviews, or do you know from your work with state courts whether this has come up as an issue?
I've not encountered the issue, and I'm not an expert in the field. I would guess that this would be a preemption matter, but I don't know that.
Renee, any thoughts about whether we should wander towards that or leave it be?
I think maybe leave it be, but this is making me, think I want to look into this a little bit more, but I'm not sure we have to address it right this minute in this document.
Okay. Thank you. Okay.
So the thing that caught my eye was where we say that make it easy for, this is on line 73, easy for people to use publicly available recordings for inappropriate, harmful, and misleading purposes. That makes me a little queasy with First Amendment questions. So I would just maybe say, take out all those words and just say improper. Which implies that there would be a legal they would be violating some law that would be enforceable. The other, someone says they use publicly available records for misleading purposes. That's, I thought politicians were in the business of doing that anyway, but just First Amendment, that's all. If
I think
that's
a good
okay.
change. Any comments on that? Okay, anything further on this section? Wonderful.
Yeah, I have a question,
Oh.
Nadine.
Oh, yeah, Judge McCarthy, hello.
The word edit in the last sentence. I'm not sure we want to use the word edit as opposed to redact. I don't think we want agency personnel editing recordings, but that's my initial reaction, is that you may want to redact. May want to redact certain recordings for public access, but I don't think you want to edit the actual recording, because I think that suggests some type of sleight of hand.
Mhm.
So since I put in the word edit, I did that mostly in response to Jeff Lover's comment last time about, you hit record early on and you have chatter at the beginning or chatter in the middle or chatter at the end, unrelated to the proceeding. You talk about the weather at the beginning or something like that, and that gets edited out. But there may be a better word for it, or we may not want to touch that entirely, but at least that was the intent behind the word edit.
Prepare.
That works.
Judge McCarthy?
That's fine. I'm just concerned about agency personnel who may or may not be directed to edit or prepare a recording that doesn't accurately record what was said that the public should have access to. That's my concern. So that word edit bothered me. Prepared is a little bit better. I would, it's still.
Well, it has to be qualified personnel. So hopefully we are mindful of who has their fingers on the editing buttons.
Well, so what? So what if it comes from the an agency of the general counsel, and they say, get rid of this, edit out what was said? It's a possibility. I'm not suggesting that would be a frequent occurrence, but it shouldn't be permissible if you're going to allow the public access to the actual content in the recording.
Does as appropriate get to that point? Meaning it would be inappropriate in some cases to edit, but in other cases it would be appropriate or could be appropriate.
Okay, I guess that's better to alleviate my concerns.
Yeah, Judge, can I just make a general response to your concern, which is, I think that we've always shied away from putting in lawfully do X and Y and Z, because we always assume that everyone's following the law. And I think that, basically nothing in here, I don't think anything in here could reasonably be read to authorize, unlawful conduct or, conduct in violation of any freedom of information or any other requirements. So I think we're fine. I think, other norms would take care of any issue like that might arise.
Okay, fair enough.
Any other comments here? Great. So again, here we have a point related to the concerns raised by Legal Services and Empire Justice. I'm wondering if this is still consistent with what we said above. Depends on access to internet connection. I think there was concern about the space. Let's see, Russell, I see you first, so.
Yep. Yeah, my sense was that the paragraph covered the points made by the letter. My only, and it really is a question, I don't know what the protocol is. Would it be inappropriate to cite that letter, which of course will be on the public website anyway? Just put it in a cite it in a footnote as an as an explanation of some of these these problems. But I don't know what ACUS's policy on that is, but I just offer it as a suggestion. It recognizes that we appreciate the points that they made, and we've tried to cover them here. But I leave to others whether that's even proper.
Thank you. I don't have the answer to that. I suspect Jeremy might know. or Matt.
I will defer to Reeve or Matt.
Reeve. Oh, Brett, Reeve, yeah.
Sorry, Jeremy, do you mind restating the question briefly?
Sure. So access to a suitable internet connection and a space from which to participate are issues that the public commenters go into in some detail. Russell asked if it would be appropriate or if there's any precedent for citing to the comment letter as support for or as additional information for those points.
I would cite it at the end of the paragraph, I should add.
Sure.
Go ahead, Reeve.
Yeah, I can't think of any instance in which we've done that. Yeah, I guess I'd defer to Matt on sort of the appropriateness of it, but yeah, I can't think of a specific instance in which that's been the case. But to my knowledge,
There's no, the committee should do what it wants here. There's no precedent for doing this. I guess one question I would have is, would it be better to cite to the underlying sources cited in the comment letter as opposed to the letter itself?
And there were several that they cited. Hi, did you have a comment about this particular discussion?
Yeah, my first instinct had been, oh, that would be nice to cite to the letter, but I think maybe one of the reasons there hasn't been that precedent is then lots of people put in letters and then they might be looking to see their letter cited, and then committees are trying to figure out which to cite and which not. So given that, I think we will meet their needs by actually using some of their language, which Jeremy nicely put in the side there. If you remember, we originally had people with disabilities in the first version, and then based on our discussion ended up sort of taking that out. One clarifying question, I'm assuming that the version they were seeing was the version without the changes from the last meeting. Is that correct?
I believe it would have been both versions. I think the commenters are on the call, and we're certainly on the last call.
Okay. Well, it is true that we, had taken out disability before, and I just wonder whether now that we have their language, there are, however, specific segments of the population who cannot participate. I'm just reading from Jeremy's comment there, so you don't have to write anything yet. Such individuals fall within 3 primary groups: the low-income individuals, power to create the barrier, individuals with disability, and individuals with limited English. Among these disproportionate. And I'm just wondering if that can substitute, and then adding a space. You see what I mean? It's a little more complicated, I guess, to do on the phone right now, but I mean, on this meeting. Further significant challenges may arise due to the fact that the effectiveness depends on individuals' access to a suitable internet connection, a personal device, and a space from which to participate, as well as their ability to effectively participate while operating, may create a barrier for individuals. Maybe all we need to do, now I'm just comparing that to what's in the comment, maybe the only thing is to make sure that we have those 3. I will tell you that there will be some duplication, right? if you put in the 1, 2, 3 completely. There will be some duplication, but no, not terrible duplication. It's the topic sentence is, here are the issues. And the second is the group of people.
Well, I do think the way it was phrased before was to generally speak about underserved communities and then give examples of how it might relate to the recommendations. So we were focused on internet access. If we want to try to round out a little bit the communities aspect, I think it should come after. I mean, I think we can use the underserved communities as
agree.
the broader, right? And then
Yes.
work
Yes.
that in, such as.
And such, well, such as, so keep, okay. I didn't even think you needed, I think you could have kept persons, all right, let's see what it is just with meetings, such as low-income individuals, and individuals, that actually works.
Okay.
That actually works, that's fine. And then they'll see their language, which I think is very good. And I like their language on individuals with disabilities prevent effective engagement in a setup and management, because that was part of my issue before. It's not all people with disabilities. That's nice language from them.
Bill, did you have your hand up, or is it down now? It's down.
Well, I thought after the list of 3 separate people, it would still be appropriate to say such persons may lack adequate internet access or personal devices, or may have difficulty or feel uncomfortable using a personal device or internet-based video conferencing software to pay. In other words, to get, I mean, as we said, we have lists of people, and why is it a problem for them? Because of lacking adequate access, or because they have difficulty or feel uncomfortable. So
I think we do cover that in 1. Creates a barrier to access to high quality personal devices or to private internet services. Or maybe that's more, I just didn't know if that second sentence is now captured in 1. Hi.
Yeah, I think we have that in the topic sentence. That's the topic sentence. Depends on individuals' access, blah, blah, blah. As a result, may create a barrier to access for individuals who, and then part is their poverty creates. So I think I don't think we need such persons may lack adequate internet, because that's duplicative of line 79 to 80.
Yeah, I think we still had some, let's keep that.
And that should keep, because, and then there's some individuals that just have difficulty or feel uncomfortable, you know, and
that may or may not be part
fall.
of an underserved community.
Exactly. And again, remember, the agency may or may not permit someone who's simply uncomfortable to not participate, but they should at least have a process by which they hear that concern and make a decision, as opposed to someone who actually doesn't have access.
Judge Manuel.
Yes, I was just going to kind of reiterate the same point, I guess, but that Bill had made earlier, which is that people feeling uncomfortable or having difficulty, but it's sometimes, you know, the more accurate way to put it would be who don't have experience with techie skills, or who haven't used Zoom or WebEx very often, or so. I think you would want to include that group as well, just people who lack experience using this equipment.
I think we cover that in the line that follows the, okay, yeah. Some individuals may have difficulty, feel uncomfortable, or lack experience using both the device and the software. Okay. Judge Manuel, does that, I think that, yeah, okay. Anything further here? Great. Okay. And then, is that the last little bit of that's this last bit here, lines 105 to 107 in the preamble. This was Bill?
It was not clear to me that this last sentence here about the tribunals around the world, it didn't sound like these were virtual hearings as we've defined it. It sounded more like the old-fashioned situation where people had to go to a particular place in order to participate. And it was even that, it wasn't even clear to me about the Department of Veterans Affairs, but it developed its own video conferencing software. And how does a person have that on their personal device? That's just what was unclear to me, is how this fit into our virtual hearings.
So with the Department of Veterans Affairs, and Fred, you can speak to this as well, they've actually created their own telehealth platform, which is actually available through an app store on your phone, which is also the platform they use for virtual hearings. So it's sort of a proprietary Zoom. Fred, you may have more information how that's functioned. As for telepresence, that was mainly included to show that we've looked at different ways of doing remote hearings for decades now, going from paper hearings to telephone hearings to traditional video hearings, now virtual hearings, basically signaling that the ways in which people can participate remotely are constantly changing, and that virtual hearings may be useful now, but in the future, maybe traditional video hearings are so good that it is worth sending people back to a remote office, that there's countervailing concerns. And as the technology develops, agencies should be attuned to that. But I, of course, defer to the committee, and Fred, you may have thoughts.
Just very quickly, Veterans Affairs has, as Jeremy's indicated, its own developed system. This refers specifically, as you note, to much, much higher resolution and architectural design. That word is fancier than it should be, so that you almost feel as if you're actually there. That is what this recommendation calls a hybrid arrangement, as far as that's concerned. So it does come within this. Furthermore, whether it's phrased this way or not, it's worth noting that the technology keeps changing and improving. And right now, some of you are probably doing the same. I'm looking at 3 screens. It wouldn't take very much for that to become an entirely immersive experience. And I am actually part of a project run out of Australia that is working on doing exactly that. And they've been working with the courts in Australia.
I'm still not sure what the last sentence in this paragraph adds, other than you say things will develop. And I just found it confusing because it sounded like something we weren't talking about. We didn't relate it to our recommendation. So I really think that the last sentence should come out. I mean, leaving in the Department of Veterans Affairs as you've described it, but I don't know what this last sentence does. Just confused me.
Aye.
No, I think that the last sentence is good. And I wonder if the issue is that we need to make it clear that they're at different specially equipped sites. Because I think, as I understood you, you were saying, this sounds like back to ordinary, everyone's in the same place. And they're clearly not, right? I mean, this allows people to stay in their own city, right? But go to some specially equipped site in their own city, and it's so sophisticated, they're not relying on their own computer. And I'm just looking at one screen as opposed to 3. So I think it fits, and I think it's I think it's a good point to, as an example for 101. You know what I mean? Recent years have seen rapid developments. And I think it's a good point for us to make, particularly because of what we were just talking about before, that all these issues of people who don't have their own devices and they don't have access to internet, and that's one of the reasons we have some concerns, but we are messaging, we're telegraphing that some of those concerns might be addressed. They might be addressed with these new advances. I just wanted to focus on the different sites.
Jack,
Yeah, I'm a little bit with Bill, but I think the reason that this sentence is seems to be hanging there is because there's no tie up. Then what is the point? I mean, I guess I want to ask Fred this or Jeremy. What is the point that we're trying to support with that sentence that's in this paragraph? And perhaps it needs an additional sentence to tie up. Like where does this take us?
What I would add, if you want to do that, is something to the effect of, oh, wow, Jeremy's been typing, future technology improvements potentially could include or something, or potentially includes and something on that order. Simply that this is a moving target.
I think if you could take a look at the language that Jeremy's just added, which I think might create some connective tissue there that Jack is pointing out might be lacking, and Bill as well. So the idea is that, and I think the opening line talks about this idea that there's this increase in use, it's continuing to develop, here's where it's going maybe, and so this is an example.
But maybe there needs to be a tie-up that says something like, this recommendation should be understood in light of the potential developments, or not to predetermine what the reaction will be to these developments, or something like that. Otherwise, it seems to me that I still am not getting what point we're advancing with the notion that there's going to be these maybe advances in this other format, which is where you have to go somewhere special to engage in the hearing. I guess I'm still at a little bit of a confusion as to how it advances what we're trying to do in this recommendation.
So what you want to say is something like, this recommendation is focused on a relatively new form of remote participation, virtual hearings. Agencies should use this to implement virtual hearings, but should also be aware that developments may be in the works that could change how people participate remotely in the future.
I mean, if that's what we think, I'm not sure that's what we think, but if that's the point, I'm just trying to figure out what the point of putting this in here is. Does it advance our recommendation, or explain to someone what the role of our recommendation is, or something?
So Jack, and I think maybe Bill could chime in as well, your suggestion would be to just delete that last sentence, the for example sentence?
Well, in my view, either delete it or do what Jack says, which is try to explain why it's relevant to our particular recommendation, which deals with virtual hearings, not with these kinds of hearings.
Or maybe move it to more way up to introductory material, so that it doesn't, because now it's sort of embedded in the buildup to what our recommendation is going to be about. Something like, you go way up I can't, something, where we describe these former, the old sort of method of these kind of hearings. I'm not sure. It just, otherwise, I'm not getting what the point is, that it's at this point in the recommendation, it still is the preamble, but I'm not getting what point it's advancing and given its position in the preamble.
Hi.
So it may be that the answer is to move it, but I guess I want to come back to the point I was saying before, that I would like it if people who are poor or people who have disabilities and can't manage their own, devices as well, would be able to go to some place very close and simple, and therefore be able to participate. So because I think it is so important, and I think we've done a good job of making sure that this recommendation doesn't say agencies should use video conferences, you know, as opposed to agencies should be aware of both the benefits and potential pitfalls. Okay. And I think we do a good job of that. I think there is utility to saying, and maybe not stuck in the middle of this paragraph, that some of our concerns may be alleviated as technology develops, and agencies should stay on top of that. So maybe it's the topic sentence that's different. I can't, can you just scroll up to see what's right before this? Agencies have developed several methods. Sometimes they use that. They use the training sessions. And maybe it's that it's the lines 98 to 100 that sort of don't belong here. You know, that is an opening thing. You know, they've increased demand, you know, I mean, just put that bracketed for the moment, though highly, you know, another reason also continues to develop fits into the previous idea, right? They've developed several methods required. In addition, video conferencing technology also continues to develop and hence can address some of the issues noted above. Recent years have seen rapid developments in internet visitor and personnel will have the potential to revolute. Well, then we won't need that addition because we will have, can address some of the issues. Recent years have seen rapid developments, telecommunication personal devices. At least one federal agency has developed its own video conferencing software. I don't know if that fits there. That sort of fits into the paragraph of 91 to 97, where agencies have devised several methods to address these concerns. So why don't you just try putting at least one federal agency, the veterans 104 to 105, after, let's put it after there for the moment, has developed its own video conferencing software. I don't know if it's that addresses some issues, but then take out 99 to 101 with the idea that it might be fitting well above because it references Fred's piece, 8 to 11, 17, that could go above. And then just in addition, instead of another reason, in addition, federal video conferencing technology continues to develop and hence can address some of the barriers discussed above. And don't have the potential to revolutionize. You know, need that because we've done it more clearly. All right, let's see.
We still have the last sentence that was the impetus for all of this, but
now it fits. Video technology continues to develop. Reason I've seen development. It's sort of like, not even for example, you know, well, no, for example, just keep for example.
I think for example would work.
Right, and then for example, some producers are now exploring the use of telepresence, which rely on high quality.
Is it, Jack, do you have another point? I don't want to cut you off high. I think we have a lot here that we can take in.
Well, I mean, I don't, it seems like we're trying to shoehorn a point that may not really belong in this place in the recommendation. So if you go back on the preamble to line 32, that's where we describe this sort of hearing, right? In that area. I guess I'm looking at the old version. So go up, you know, the paragraph above that, like, when the the paragraph starting on line 23. So I think referencing that the technology here continues to evolve, and I think I think our recommendation is more focused on making sure that if people are going to do what we say in the next paragraph happens, that it's done properly. We're not actually. I don't think we're saying to agencies like don't have these hearings where people have to go to a special place anymore. Those may actually be better. So I think that if we put the stuff that was in that area, about the evolution of this technology and the worldwide and that sort of thing, throw it in, put it in here, it actually then, it helps frame the whole recommendation, which is we're not, I don't think we're telling agencies to prefer virtual to the old fashioned whatever we call this one, traditional video here. And so what really, this is a point which says that traditional video hearings are getting better. That's fine. I think it belongs in this part of the preamble, not in the part where it is now. That's all.
Is there specific language below that you think should be moved here, even as revised by?
Well, once the way Kai revised it, it doesn't fit. It doesn't work. But if we go back to the initial language that was in the recommendation and put it all in here. Go back to the initial language on the other part also,
Is it possible, Jeremy, to show the revisions without the strike through so that no, I meant sorry, with it, but so that you can read it clean, so that there's no
yes.
I'm sorry, I don't know what to call it, the tech challenge
Accept the
person.
change. Yeah, accept the change.
There we go. So that we can see how it flows and if this is accomplishing what I think Hai was trying to accomplish, and maybe it addresses. Anyhow, could we read? Let's see, where do we want to start?
Because
so we're talking about the concerns. We're talking about what they can do to address the concerns, training.
But this better traditional video conferencing does not address the concerns about what we're calling, I can't keep the virtual hearings, right? It may be that there are improvements to traditional, what do we call traditional video hearings?
Yeah.
And that's great. And that may lean agencies towards preferring those over what we're calling virtual hearings.
Okay.
So I would say, I don't think that improvements to traditional video hearings address the barriers to virtual hearings. They're just an alternative to them. And as they get better, it may be a more preferred alternative. So I would put all of this up, I would take out the in addition. Video conferencing continues to develop, and take out the sum of the barriers, and then and the rest of it, which I think is interesting, but it belongs up near that one of those opening paragraphs, in my opinion. I'm just one person. It's the committee's obviously decision.
Well, to the extent that we can make some changes and see what people think of it.
I agree. It certainly addresses my concern. I think Jack's spot on on this.
Okay,
I agree.
thank you.
You cut a sentence which I think still belongs. Oh, there you go. There you go. No, wasn't there more? Wasn't there more to that? Video conferencing continues to evolve. Yeah, that stuff.
I hate that it doesn't let you copy deleted text.
I know,
Jeremy.
sometimes you just really want to, right?
Exactly.
What I do for that problem, just to a little internet, and my second of my 18 screens that I'm surrounded with in a total circle here, is I have the original version up, and I can just copy out of that if I want to go back to something.
Yeah.
That's a good point.
Okay, so the flow here is off, I think. There's another reason, I'm not sure. Well, we can read all of it, but I'm already reacting to another reason. Okay, thank you, Jeremy.
Yeah. And we can work on just a flow.
Smoothing it out. Yeah, sorry. So does this fit here?
I think the first sentence can probably go. recent years of react development, internet-based video conferencing software, that's redundant then, right?
The recent year sentence?
No, the first sentence, video conferencing technology continues, or else take out the recent years have seen something. I don't know. It seems like it's redundant right there.
Yes. I think that works, actually. I was skeptical, I'll be honest, Jack. But I think that actually might fit there. Can everybody just take a look, maybe read it, see what you think? I know Russell already said he liked it, and so did Bill.
I believe that later on we're explicit that we're not promoting the use of virtual hearings over traditional video traditional video conferencing. So that would be important to tie this up also.
Like this.
Thank you. Russell? Uh-oh, we can't hear you. Unmute.
I like the change. Just a small point though, then on line 36, more recently seems out of place. We're talking about the future and then more recently than the future. Agencies have also allowed something like that.
How about in recent years or recently?
Anything to get rid of the more.
Yeah, just put recently.
That's fine too.
Professor Landers.
Back up into the stuff that's now in red that we just added, maybe change the word develop. Video conferencing technology also continues to develop, to evolve, because the developments in the next sentence there, it's a little.
Yep, that's a good edit. I like it. It's a good sign when people are starting to edit what we have there, Jack. Thank you. Any other comments on this particular section? Russell, did you have something else?
Just one small point. It goes to something I made later, when we get later. This idea of the perception, it almost sounds like fooling the folks. We're tricking them into believing something that isn't true.
Oh, yes. Yeah, you did have that.
Rather than the perception, something like the sense or the, I don't know, anything other than just, we're fooling people to think something's true that isn't true. Jack may have the better word for it, but the perception, well, I told you why it bothers me.
How about experience?
Anything.
Well, you could also say sort of, more closely approximate the,
yes, yeah,
the hearing when everyone is in the same physical space.
Well,
how about an experience? How about an experience equivalent, or nearly equivalent to a meeting in the same
The
facility?
word I suggested later was simulate.
Yeah, that simulate is also a really good word there.
Yeah, I like simulate.
That simulates meetings?
Simulate the experience of meeting in the same meeting in the same physical space. How does that sound, Russell?
Sounds fine to me.
Fred, did you have a hand raised?
I would have simply said the feeling, which is simpler, but this language works.
Okay. Anything further on this language, right where the cursor is? Okay. I think, do we need to go back down to where we were? I can't remember if we've just pulled everything up. I think we did. What about the bracketed language? Is that up? In the other part? Jeremy, did we move that up too, or no?
Didn't.
I think that would be good as a second sentence in the paragraph starting at 95.
Any thoughts on that? Okay. Are we done with the preamble? Is it possible? That would be great.
Yes.
We are. Excellent. Okay, so we have made some, let's start with the changes that we made to the sections that we've already talked about in the last meeting. And hopefully we will move quickly then to the section that we did not yet discuss. So Jeremy has a comment here about our list, which we did discuss last time. Bill.
I would say agencies should consider rather than should balance. I mean, I understand it's all these weather. And I think that's what you consider. You don't balance the weathers.
Russell? Okay, that's fine.
Fine with me.
Any reaction to Jeremy's question about whether the list should be exhaustive or non-exhaustive? I don't think it should be exhaustive. That's just me, but.
I don't think you need among other relevant factors in order to make it non-exhaustive. I mean, they should consider the following, but it doesn't mean you should only consider the following. I think should consider the following means at least these. So I don't think you need it to make it non-exhaustive.
Any reaction to that? Jack?
I'm going to have to disagree with Bill on this drafting because I think when you make a recommendation that says, here are the things you should consider in administrative law, if you consider something else, that's consideration of a factor that's not a relevant factor. So I understand what Bill is saying in ordinary language, but in legal language, that would make me feel a little queasy.
Okay. I think I saw Renee shaking her head as well. Hi.
I will go with this. I just think that if I were reading this in an agency, I would just say, okay, and what are they thinking about what might be the other relevant factors? I mean, we have like a lot of stuff here, but I'm completely fine with keeping among other relevant factors. And
how about consider
we'll just say maybe
consider at least the following.
I see a nod for at least.
Yeah, but the thing is, you just need to be ready if someone says, okay, and what else were you thinking? But to consider at least the following, I think that's probably better than among other relevant factors, because that sounds like we had ideas about other relevant ones.
Bill is nodding. Any other thoughts on at least? Okay.
I like it.
All right. Jack, who raised the concern about retaining the language.
Yeah, I would put out to the group whether they feel more comfortable with at least or at a minimum.
Any thoughts on at a minimum? Renee, we can't unmute Renee.
I prefer at a minimum to at least, but because you should consider, but doesn't mean they're all relevant to you. But this is why I like.
Yeah.
This is why I like among other relevant factors. So better, but maybe we've passed that point. So.
Any other thoughts on at a minimum? Tristan, did you like at least better?
No, I think both of them to me
Okay.
are really good.
Okay, I think it's at a minimum. Next one. So this is the area I think we can reconcile this with what we did above. Jeremy, does that make sense?
Yep.
Great. I'm always happy when work, a heavy lift we've gone through can just flow right on through. Perfect. Judge Manuel?
Yes, Nadine, are we going to go through these at each of these? We made the point that at a minimum, but I just didn't think it added much, but I thought that, you know, we should at least cover sort of the obvious or ones that we feel at a minimum they should consider. But I thought what was sort of left out here in terms of logistical issues and suggestions on C might be kind of cybersecurity issues.
So I think we discussed, Jeremy, just remind me if I'm wrong on this. We discussed these last meeting.
We did.
And I don't remember if you were able to attend last meeting. I'm thinking not. We did go through.
Initially, yes. Uh-huh.
Okay, so we did go through these. And I do think that point came up about concerns about making sure there was adequate technological safeguards in place. And
Yeah.
I think we covered, yeah, thank you,
Recommendation
Jeremy.
5. Yep.
We decided to carve it out as kind of, you know, a specific, not just maybe consider it, but this is something very important, important component of doing a virtual hearing.
Okay. Mm-hmm.
Does that help?
Yes.
Okay. Recommendation 2, we had a therein. Okay. Recommendation 4, this is a new, oh,
Nadine,
sorry, Russell, yes.
I just think, I hate to be this way, I think 2 could be a lot shorter. Agencies should determine whether any provisions of their rules of procedure restrict. Are there any provisions of their rules of procedure restrict? Just saves words, that's all. That's my only point.
Matt.
I may be revisiting something on 2 that had been addressed at the last meeting, but 2 doesn't, I have a couple sort of questions, maybe concerns with 2. The first is, it says agencies to determine whether any provisions of their existing rules restrict the adjudicator's discretion. And if they so conclude, then what are we telling them to do? That's kind of a small point. The other question here is, maybe it's not such a small point. What happens if they want to restrict adjudicator's discretion? Maybe that's covered by paragraph 1. I don't know. The second question, though, is it's a sort of a broader point here. Are there any other recommendations we're making that the committee might want to make to agencies about, in effect, codifying their guidelines and protocols and procedures with respect to virtual, maybe video hearings too, in their rules of practice? I mean, ACUS, and maybe this is a question for Jeremy, I'm not sure. I mean, ACUS has generally taken the position, sort of, if I can characterize it as such, that when in doubt, put the procedures in the rules of practice. Don't relegate them to guidance documents and so forth and so on. And so I just raised that question for the committee's consideration, whether the committee wants to tell agencies that they should address other matters, or at least consider addressing other matters relating to virtual hearings in their actual rules of practice.
I do recall we had a conversation at the last meeting about allowing adjudicators to retain discretion to decide whether to do this. So I think there was some concern that we make sure that discretion is maintained. Tristan, I saw you nodding.
It was discretion that was consistent with agency policy. And is that adequately, I thought that's where the committee ended up. Jeremy, do you recall on this?
I think that's correct. The agency, so it says here, when such participation would otherwise satisfy the principles in paragraph 1. Paragraph 1 is agency should consider fairness, efficiency, participant satisfaction. So presumably the agency is setting the overall policy and then allowing adjudicators discretion within that policy determination. At least that's how I read it.
Okay, that's fair enough. That sounds, if others agree, that sounds fine with me.
One suggestion.
Yes,
Yeah,
please.
sorry, no, there's a couple hands up.
No, totally fine.
One suggestion might just be to put something like unintentionally. Shoot, what's the language now? Whether unintentionally restrict adjudicators. I had read this. I mean, like you said, Matt, if they made a decision, they made a decision. But I had read this as you consider it, but see if there happens to be just anything else that wasn't on the policy radar that in practice is actually impeding this.
Right.
Any reactions to that? Jack.
So maybe I'm misunderstanding what you're talking about, but I'm recalling in number 6 of the recommendations, there's an extensive, the only thing it doesn't have is it says they should develop guidelines and make them available. It doesn't say in what form. So are you saying that in number 6, we should say that they should codify them into their rules of practice?
What I'm doing is, and thank you, Jack, for pointing out paragraph 6, because that is the key. I see that is the key paragraph. The question is whether it's just a question for the committee, whether it has a view as to whether certain practices, procedures, protocols, and so forth with respect to virtual hearings should appear in their actual generally CFR codified rules of practice or procedure, which is generally what ACUS has recommended with respect to procedural matters, which isn't to say that there aren't any number of things that can't be addressed through guidance documents on websites and similar such documents. I'm just raising the question, given ACUS's general preference in the past for putting things in formal rules of procedure rather than relegating them to other documents. But it's a question, really, and I don't know if Jeremy has any thoughts on it, given ACUS's past recommendations. If you think the committee thinks it's not something that should be addressed, that's certainly fine with me. It's just a question, given ACUS's past recommendations.
So I think that maybe where we say makes those guidelines publicly available in an appropriate location on their websites, we should say consider inserting them, or however we would say it, and consider including them in their published rules of practice, in their published and codified rules of practice. And then maybe that makes that one above a little bit redundant, in the sense that they got to look at their rules and maybe consider making amendments if necessary, something like that. It seems to me that those 4 and 6 are closely related in that sense. Review your rules, include these in your rules, review them, and if there's anything in there that's an impediment to what you want to accomplish based on this recommendation, consider making amendments. But I think that, Matt's instinct that things like this ought to go into the CFR I share that. I think that ACUS has been pretty consistent about maximum transparency in many different areas, and this would be a good place to include that also.
Judge McCarthy.
Thank you, Nadine. Yeah, I was just going to agree with Matt and with Jack. I think they should go in the agency's rules of practice as a practical matter. And I think, Nadine, you have experience with this. It's very time consuming to get the notice of proposed rulemaking out and to include those in new agency rules. And this is kind of a new developing area. My agency's dealing with it now in virtual hearings. So I think we should say something about, I'm just thinking out loud, but that agencies should review their rules of practice in light of this the technological advances in virtual hearings to consider.
Judge, are you back
recording
up?
and-
Can I just stop you for a second? Are you back at 2? Is that where you're suggesting the language would go?
I mean, I think agencies should update their existing rules of practice to do what 6 does or what Matt is suggesting. So I'm not sure it goes there, but I think we want to
Okay.
encourage agencies to get ahead of the curve here. So that's my point. That's my point.
I'm trying to figure out if there's a way to build 2 in below, or if the below should move up. I mean, I hear people saying that those 2 concepts, 2 and 6, seem to be related. Hi, do you have a thought?
Yeah, I mean, I think they're related, but I think logically they should come differently. And I want to reinforce what Judge McCarthy said about let's not tell them they should update their rules of practice when that could take forever. So I think number 2 is, look, we've told you to consider all these factors. After that, you should determine whether any provisions of your existing rules of practice unintentionally restrict adjudicators' discretion. Because if so, then you need to figure out what to do about that. Okay, so I think that fits. Then I think 3 and 4 and 5 are all additional things that we wanted to pull out from the general factors
General
to
list.
consider. The general list. Here's 3, 4, and 5. Okay, then 6 is absolutely key. Because now you have to have guidelines by which people can request not to appear virtually, as well as to appear virtually. And we cannot wait for those to get into rules of practice. Now, and consider including them may be fine, or you can say, do this guidance and then, take that out there and say these, these guidelines should ultimately be included in their public rules of practice. But get those guidelines written and get them on your website, and they address as applicable all of this. And then at the end, can we say, per our usual practice, such guidelines should essentially ultimately be included in the public rules of practice. Or just, and consider including them. I mean, consider including seems to back off of our usual approach of don't just consider including them, but do include them.
But you would move that
wanted
down
to-
after we discuss what the guidelines should address. And
Should
then,
be, I think, I don't see if you can scroll down. I'm sorry, I don't have the original next to me. Any protocols, okay, G, da. See, you don't want all of these protocols, whether the petitioners could have their microphone on or can consult privately.
these are
I mean, it would
guidelines.
drive us,
Mhm.
these are guidelines.
And
So
frankly,
maybe upfront, consider as appropriate. No, I know we hate as appropriate.
Okay, so let's just bear with me here. Can we go back to 2 and see if we're done with 2 as it was revised in terms of the barrier to, now we're using barriers again. The idea that your rules as they currently exist may make this a difficult exercise. So you need to look at that. And then
And you need to look at
3,
it, but you need to do something, not just look at it. If you need to look at it and make, corresponding changes or,
Okay,
or change them as, something like that. You don't want to just say, look at.
Yes.
if so, agencies should.
Changes, not chances.
Yep.
Changes.
Thank you.
Okay.
Yeah.
All right. 3 we talked about last time, so we can leave 3. 4 and 5, I think, as Hai pointed out, are things we wanted to kind of pull out of our list, right? 4 is brand new. And this was discussed at the prior meeting. So before we get to our guidelines, let's iron out 4 and 5. 4 being new, I figured there may be some more discussion on that. Judge Manuel.
Yeah, I'm sorry if we covered this before, but before we go past 3, should we add in there minors, people under age?
Where would you add that?
That, you know, that we should consider these special issues that might come up with respect to privacy regarding national security, law enforcement, confidentiality, privacy of the parties, and how about underage persons? There are certain kinds of administrative hearings that do involve underage children, and in those cases, they would almost always be matters where you would consider the privacy and not make the proceedings publicly available.
Would you tack that on to the privacy D? Or it
Yeah,
would be a separate, okay.
I think so, e.g.
And this is taken directly from 2016-4. I mean, again, the committee can certainly vary from that, but that's where this language comes from.
Any thoughts about adding that? Judge McCarthy?
Yeah, with all due respect to my colleague, Alex, I mean, I think privacy covers it. And if it's coming right from
The prior?
the prior, I would keep it, because I can think of other exceptions too. I think we want to keep it short and
Broad.
succinct. And I kind of like it the way it is, but I
Okay.
understand the concern about the minors.
Hi, did you have a comment on this particular point? No, I see her hand went down. Okay. Okay. Any further thoughts? We'll leave that broad, Judge Manuel?
Yeah, I think it's fine. It's just that there just is a whole body of cases and areas of practice where privacy is routinely maintained. And I'm thinking of immigration cases in particular, where unaccompanied minors is a major issue. And although the hearings are generally public, they have a special process with respect to unaccompanied minors, and privacy is a major issue. But that's the reason why I raised it.
Is it more the parties or the participants? Are you concerned about, I mean, I guess that can be broader
Yeah.
than just the parties.
Yeah, sort of both, because they often have witnesses of the children of the immigrants and that sort of thing. So that's an issue to flag for people, that where minors are involved, keep in mind the special privacy issues that might be involved.
So maybe would participants work better there? Is that a broad enough term to encompass?
Sure.
Any thoughts on that? Judge McCarthy,
Yes.
how does that sound to you?
Is hearing participants broad enough to cover parties?
It's a good question.
I think we've used it in the preamble to encompass parties, but
In the opening paragraph, we say communication among participants, comma, including parties, the representatives, and the decision maker. So I think we're good with participants.
Great.
Any other thoughts on that one? So we can move to 4. So I see Russell has some comments here. One was to delete carefully, which suggests that we would never be careful. We might not be careful. And moving the phrase, among other things.
Well, yeah, I would suggest, as I always do, not to ensure, but to seek to ensure. We have laws against red light running, but people still run them. So seek to ensure, and then put the among other things after ensure, because those are the various objects of that verb.
Any comments on that? Okay. That one is good. All right. 5. Whether we want, Jeremy has a, well, I know there's 2. I'm sorry. Russell, you had it.
I'm fine.
Okay. And then Jeremy had a comment, a question about whether we should reference any government-wide programs or offices such as FedRAMP.
I think that
I
was
confess.
Yeah, I think FedRAMP was raised in the last committee meeting.
Yeah.
specifically.
I think this covers it, but I'm open to hearing from my fellow agency folks if there's thoughts about including some specific programs here. Bill,
My concern was personnel. It makes it sound like only government employees as opposed to by contract or outside people. And maybe if we made it a little phraseology that was a little broader, it would include, without specifically mentioning them, the agency programs. So my concern was the suggestion that this was only people that were employed by the agency. And I didn't think that should necessarily be true.
Roxanne.
I would say if that's a concern, just change the word personnel to professionals. And then with regard to referencing something like FedRAMP, I would stay more generic because things change in the IT area so rapidly. We don't want to tie ourselves to something that might be outmoded in a few years.
I think that's a great point. Tristan?
Sorry, same point. Even if it weren't going to change, just FedRAMP seems to me more down in the weeds to mention that.
Yep. Okay. Bill, did you have another point? I see your hand. Okay. All right, good. So are we good with 5? Okay, we are at 6. Before we tackle 6, we are at a good break point. Why don't we take a 10-minute break? And then we had some thoughts, I know, on 6 that we started to talk about before. So 10 minutes. We'll be back at right before 1:45. Does that work for everybody? Thank you. I think we can, Jeremy, you're there? I see you now. Let's give it a second here and we can get started again. If Matt is on.
I am on. Thank you, Nadine.
Excellent. And I know you you had a comment about 6. Let's kick that off.
Yeah, I just wanted to return to my original comment about whether agencies should at least consider codifying certain things in CFR rules of practice. And I just want to be clear, apropos of the excellent point that Kai Feldblum made, that I would not suggest that ACUS in any way suggest that all of these matters listed in 6 be addressed in formal rules of practice. There are some of them that I would think an agency would almost certainly want to include. For instance, probably A and B, any process by which parties can request to participate virtually. That could very well be the kind of thing that an agency might want to address in a CFR rule of practice, just as they might want to address processes for parties, opting out if that should come up. And Social Security's rules of practice, for instance, are pretty specific in terms of some of the issues associated with video hearings, at least. So that's all I wanted to add at the outset.
Thank you. I guess I wanted to echo Judge McCarthy's point, which is that this is, a new evolving area. And to the extent that agencies are trying to sort out guidelines ahead of formalizing rules, I think that makes some sense to look at it that way as well. So recommendation 6. Any thoughts about how to include, if we want to include a recommendation to agencies to at least think about making them part of their rules at some point when appropriate, as relevant, all those great phrases we love at ACUS. Oh, Tristan.
So maybe I missed, but I like what we have here. I
Okay.
think what we have here makes the suggestion there, and so I'm good with this how it is.
We might have too many ands, but I think the Committee on Style can work that through. Any other thoughts? Hi.
I'm just wondering whether we need to say, and I don't like saying some, but consider including some of them in their public rules of practice, because, I think all of us agree, it's not everything.
As relevant as, we have those great phrases we love.
Well, do we love as appropriate? I thought that.
As relevant as to the extent feasible. Some is fine. I'm just.
Yeah, it's not the best, but I think it's probably better than not qualifying it, because we just seem silly then. And consider including some of them in their public rules. So they develop the guidelines, make those guidelines public available permanently. That's taking out the and on 170.
The first and.
And consider
including some.
And consider including some of them in their public rules of practice. Should address as applicable. That works, I think.
Okay, Judge Manuel and then Russell.
Yes, I just was wondering if there were some areas on some of these where we could take into account the concerns raised with the legal services in New York City. I just know that one issue, and I think it really is a big issue about having access to the technology. And so I wondered, I was working from the old draft, so it was the old F little I, how and when and how to join a virtual hearing. And I thought there might be a good place to sort of add in the considerations about access to locations, and whether it's libraries or some other suggestion, or of course with the VTCs, it was we would basically maintain a list. And we would say there are certain IRS offices near you or other locations, and if you go there, you can use their VTC facilities. So I wonder if it's appropriate for agencies to consider developing a list of locations, or whether it's a public library or something else that might be able to assist in the process of allowing these litigants to have access to a laptop or the necessary technology.
How does that look, Judge? The language that Jeremy's just added.
Looks good.
Okay. Thank you. Russell.
on line 175, taking Matt's point, I think others, that surely some of these would go in the rules of practice, consider including some of them, consider which one of them's, which of them to include in their public rules of practice. And that puts the recommendation on record that some of them should be in the rules, which I thought was the sense of the group. But if I'm wrong about that, obviously the language should stay.
So it'd be, and consider which of them?
Which of them to include in their,
If any, sorry. I couldn't- I've been steeped in this too long, I think.
Don't put in an if any.
Somebody
don't
will
put
bring
in
it
any.
up. No, I'm
No,
kidding.
no,
no,
take that.
No.
No.
Jeremy,
Jeremy, take it
It's a
out.
joke, it's a joke, don't worry.
And as
Jeremy's
the-
adding levity. I get it.
Right, yeah. And as the person who put in some, I think which of them to include gets both Matt's point and my point, so I'm comfortable with that.
I
Well, the
think our
premise
points
is-
are this, I think our points are harmonious, Kai.
Oh, our points are totally harmonious.
All right.
Totally.
I'm not trying to be difficult.
No, totally harmonious.
Renee, I see a hand.
Right, so now we have a lot of pronouns in that sentence. So, and then when we get to and consider which of them to include in their public rules of practice, I would say them should be which of those got, yeah, exactly. Very good.
Great.
Yeah.
Excellent. Thank you.
Hmm.
Okay. Wonderful. Russell, sorry, Judge McCarthy, did you have a comment on that
Well,
section?
I do have a comment, Nadine, about, and I was just gonna look up the APA about the discretion of the adjudicator to manage the hearing. And I think as a practical matter, a lot of agencies are leaving it to the adjudicators during pre-hearing conferences or in, scheduling in orders and things to determine a lot of this. And it's not actually coming from the agency heads, and particular adjudicators may have a different way of doing it than other adjudicators, even within the same agency. So I'm just pointing that out as something to be aware of that I think happens in practice. And I'd be interested in hearing others' comments about that.
Any other thoughts on that? Fred?
I can just confirm that there is apparently a great deal of individual variation within a single agency. That was a fairly constant theme, that each adjudicator had developed a personal approach. That doesn't say there are great differences, but there are differences.
Or whether we should try to account for that. I'm not sure if there's some language that we should consider there. Hi, did you have a comment to Judge McCarthy's point?
Yeah, I think this is one of the most important things this recommendation does, which is to say, instead of having it just largely set, at the discretion of the adjudicator, let the agency think through some of these things, especially A and B and C. So you have some adjudicators who, once the pandemic is over, is just going to say, no, I want everything, in person. There's at least an ACUS recommendation saying to the agencies, we've told you the things that could benefit people. So at least have guidelines for when people can request it. And the adjudicators who will say, I love being virtual and I'm going to require everyone to be virtual, to say guidance and see. Now, my guess is a lot of agencies, when they do this guidance, are going to build in a lot of discretion for adjudicators. You know what I mean? Just based on what adjudicators are going to demand. But I think what we're saying is we want you to give some thought to this guidance. So I think it's an incredibly important point, but I think we're somewhat pushing back on that.
Roxanne?
I think it's appropriate to push back. I think our agency probably has differences from judge to judge on their orders that they issue with all the guidelines for the video conference. And I don't think that's at the end of the day appropriate. We're coming out here with best practices, and it's not a best practice to be different from hearing to hearing within the same agency. So I think that it makes sense that there be guidelines from an agency that are consistent from hearing to hearing. So while I acknowledge that, yes, I think Judge McCarthy is correct and agree with Fred as well, I think that doesn't make it not something we could improve upon.
Any other thoughts on that? Okay, then let's move to Russell's comment about standards of conduct. Russell, did you want to be heard on that? No, we should, yes.
Not really. I mean, I just asked the question, what's the difference between standards of, could we give an example of a standard of comment? Unless that's a term of art that I just don't understand. What's the difference between E and G, best practices and standards of conduct? I'm just asking a question.
Tristan?
My thought, I mean, they certainly by the words themselves could be indistinguishable, but as I've seen it, standards of conduct would typically connote, like, if you do this, you know, or I guess if you violate these, you're out. Whereas I guess I read the protocols or best practices, just kind of helpful suggestions. Obviously, if someone's like submitting an exhibit improperly or something, it may be that it's not included in the record. You know, there could be consequences, I guess, of the best practices, but I guess standards of conduct seems to me like a phrase that's aimed at what's the adjudicative term we use to, you know, at folks who are being belligerent or whatever else.
Decorum.
Yeah.
And well, how you're, yeah.
I'm just asking the question if other people wouldn't know without some explanation what they are, whether we should explain it somehow or other. The explanations just given made sense to me, but and maybe they would to anybody reading this. I just raised the point.
Roxanne?
I understand what Tristan is saying, but I think it does look a bit oddly redundant to have E and F have standards of conduct, one right after the other.
How about the change that Jeremy just put up?
But if I were just reading this cold, like, I would think that means the same thing as in F as well. It's like your standard of conduct for virtual hearings.
E and F were intended to be the same. E is basically an opportunity to verbally explain. So F would be like a session to explain the standards in E, which may or may not be necessary, but I think, Fred, you said that was a common feature across some agencies.
Gotcha, thanks.
Bill, you had a comment.
I think I'm just saying what Fred said, which is E and F, it's not redundant, it's two different ideas.
Yeah.
Okay. Judge Manuel?
Yes, and also standards of conduct can be read to include sort of ethical behavior, which of course would be different for the attorneys there versus the parties.
So do you have language that you would suggest we add there, standards of behavior?
Well, that's why I was thinking if you take out standards of conduct, then that's kind of a term of art for lawyers. Or you typically the term would be a professional responsibility or ethics or things along. And of course, the judge, the adjudicator themselves are governed by professional rules and regulations also. So if you want to incorporate the ethical issues that apply to lawyers and the judges in particular, it seems to me that that should be addressed specifically.
I think Jeremy's got it with his change.
Judge McCarthy. Can't hear you. Can you unmute? Thank you.
Thank you. It's a rookie mistake. I'm looking at our agency's rules on standard of conduct. I think we're talking about the agency standards of conduct. right? I mean, standards of conduct, there's OGE has standards and model code has standards. I think we're talking about the agency standards of conduct or behavior, decorum, and professional responsibility for participants during virtual hearings. Okay, yeah. So I guess we're striking conduct then, is that right?
That's the suggestion right now. Mhm.
I kind
Renee.
of like
Oh, sorry.
agency standards of conduct for
Okay.
participating in virtual hearings. Because I think that's going to be covered by agency rules regarding standards of conduct. Maybe there may be some agencies that don't have those standards of conduct, but the ones that I'm familiar with have them. Usually in
And-
connection with disciplinary proceedings.
And would they apply equally to a virtual hearing? Are there special considerations of a virtual hearing that need to be taken into account? Like, I don't know. I don't want to see you in your pajamas. I don't know.
Apparel is the big one we've all seen news stories about, right?
Yeah.
I'm not-
So Renee, and then I'll go to Fred.
So, yeah, I liked conduct better. I hear what people are saying about how that sometimes the connotation for lawyers is that it involves only professional conduct, but the behavior particularly, that word strikes me as a little kind of, elementary schoolish, school. And, so I think decorum is okay. And maybe that covers it, and then professional responsibility to get at the lawyers. But I would take behavior out because it just seems a little easy to me.
Fred, thank you.
Still in these meetings.
The one thing that comes,
No, Fred.
Armando wants a book. to give to
Jack, we
Denzel
can hear you.
Washington.
Jack, please mute. Thank you.
Sorry.
No, that's okay. Fred.
the one thing that consistently comes up and is often addressed in a pre-trial meeting is to not talk over someone else. There are 6-second rules in a couple of, at least some adjudicators and perhaps agencies. Let someone finish clearly before you speak. And that is something that is unique to the virtual hearing.
Thank you. I'm going to wait. No, I'm kidding. I was going to wait 6 seconds. Roxanne.
I agree with Renee, and I would go back to using the term standards of conduct, but I'd take out professional responsibility. So if we could say standards of conduct, comma, behavior and decorum or something like that, and leave out professional responsibility, it's just, it gives me a little heartburn to say that we are going to set forth the standards of professional responsibility for attorneys' behavior during a hearing. That's pretty encompassing, and the attorneys should already understand their professional responsibility.
That's fair.
Nadine, maybe, can I
Okay.
just interrupt? Maybe
Yeah.
this would be just a good time to just announce that ACUS is actually commencing on a project on rules governing representatives in agency proceedings, both adjudicative and rulemaking and so forth and so on. So maybe it'll come before the Judicial Review Committee at some point.
Thanks, Matt. Sounds good.
Adjudication Committee, I meant adjudication.
Damn, I thought we were getting out of it. Sorry. Go ahead. Hi.
So I just want to make the pitch for returning to standards of conduct for this reason. The reason we started talking about it was Russell's correct point of what's the difference between standards of conduct and best practices. And I think that was explained. And then there was the concern that E and F were duplicative, and they weren't, right? Once we clarified that. I feel like standards of conduct, I'm not sure that I would see decorum being any different from standards of conduct. I think standards of conduct sounds reasonable. We all know them for in-person hearings. in your guidance, see if there's anything different for the virtual hearings. Remember, we're building on what exists. So I think given the concern that was raised with this, I would go back to standards of conduct in E and F.
Is there then changes to make to G to the extent that I think Russell's comment was concerning best practices and how that relates to E?
My concern, I just didn't know what the difference was, and I thought some
Okay.
explanation, even just an example under E
Okay.
might be helpful. Standards of conduct, parentheses, for participants, parentheses, for example, just somewhere along the line.
Mhm. Well, I know Fred mentioned the 6-second
Maybe
rule.
everybody else knows what they are and I don't. I mean, that, I'm not saying that facetiously either.
Maybe we can flesh that out, Jeremy. We can
Yeah.
explain what that means.
Sure.
You know, it's the idea is that people are going to take turns as they speak. Fred, did you have another example or a thought there?
There were surprisingly few reports about inappropriate clothing and the rest. What there were a fair number of reports of people appearing from automobiles. Now, whether that's something that we ought to address or not, or you ought to address, I'd leave to you. But that was something that showed up with some frequency.
Well, I think, does that then get into an appropriate location from where, you know, there was a concern about it being a suitable space and whether it's a private space and whether it's, you know, yeah, we don't want people to get in an accident. And we had the one doctor participate from the operating room and his traffic hearing or something to that effect. Hi, did you have another comment on this? No, okay. We can come up with an example. I think Jeremy, we've got something we can add there, and I think that will help, hopefully. Great. Anything further throughout? So we've got G, we added a concern that Judge Manuel raised. Any concerns or thoughts on that? I think we can scroll through. So Russell's point at that very last point before 7, whether access recording should be accessed or record on their own. Oh my goodness, we don't want them to record on their own, do we? Yeah, Russell, go ahead if you had a comment.
I would just, no, again, just asking the question. And I mean, I keep on thinking this in terms of the press. And there, you know, for a high profile hearing, we'd love to be able to record this and play it on our local news. I'm just again asking the question. I mean, other people who know a lot more about this than I do said they prohibit parties from recording. And if it's technically possible to do that, it may be a moot point. I just thought I'd raise the issue. That's all. Fred may know whether or not technically it just can't be done.
Well, technically, if I may respond, yes, you can use your phone.
Yeah.
I guarantee you can record it. That's not hard. And whether it's a First Amendment violation of an agency to refuse to let a reporter who's legally present strikes me as a fairly entertaining question. But I would leave that to Jeremy and many other experts in this room, so to speak.
I think the Supreme Court would say there's no First Amendment right to record the proceedings.
Any of our judges have any experience with that? I mean, my first reaction was no, we do not want them to record it on their own, even if they're legally, you know, they've been permitted to attend. Judge McCarthy.
My agency does not permit them to record. I think most agencies do not permit it. They expressly prescribe it. Fred raises a very interesting First Amendment issue. Should a reporter raise that and sue? I'm not going to venture down that rabbit hole, but it would be fascinating. But I think it's within the agency's discretion not to record. And Jack made a good point earlier. I think you look to state law or conflicts of law. And I don't think it's a preemption issue. I think it's a state law issue. as to whether you can record in the particular jurisdiction you're in.
Thank you. Tristan?
This also seems to harken back to some of the concerns that were discussed in our last meeting about, people manipulating the footage or other things with deep fake technology and other things like that. So I would be shocked if any agency, were willing to permit recording of hearings by
Judge
any
Manuel?
party other than the agency. Sorry.
No, that's fine. Thank you. Judge Manuel?
Yes, it's true that we generally wouldn't allow the litigants to have their own recording. Having said that, we almost always provide them with a copy of our recording as well. So there is a record. Having said that, we did have a case a few years ago where it was what we call a mortgagee review board proceeding, where we were not going to record it, and the litigant then claimed that they had the right to record it, and we just resolved it by hiring a court reporter and providing them with a copy.
Thank you. Russell?
Well, just so what's the analogy to a traditional hearing in which the judge, the adjudicator, says to the reporter, you can't bring your camera in here, and that pretty well ends it. They have the control of the courtroom. Here we have a situation in which the agency have the authority to tell someone you can't record it. I mean, do we want to say anything about this, or are we opening a can of worms that shouldn't be opened? It seems to me there's enough of a discussion about it to suggest that it's not a problem. It's not a minor problem, or could turn into a major problem in some, relatively rare number of high profile cases. That's my only point.
I'm wondering if it's a broader concern beyond just interested persons, that it would be any participant as well that might feel, I think Fred pointed out, you just put it on your phone and record it as you go. Oh, thank you. Thank you. Thank you, Jeremy.
Participants we have, yep, absolutely. So this would at least parallel that.
Any further thoughts on the language that's there?
Well, but how do
Whether
you
they-
enforce it? How do you enforce it? You can say you can't record it on your own. This is an agency policy. And
Whether they will
somebody-
be permitted, I mean, is the idea,
Well, somebody sitting at home with their phone says, well, I hear your policy, but I'm going to record it anyway. What are you going to do about it?
Well, can I respond to that? I mean,
Please.
we're talking about standards of conduct in the virtual hearing, and you just violated one. So I'm gonna either take some sort of disciplinary action. Is it slap on the wrist? Is it a suspension? Is it a warning? I don't know, but you violated the agency's standards of conduct for participating in a virtual hearing by recording the proceeding. Now, whether you want to sue me on First Amendment grounds is a whole nother issue, but that's how I would handle it.
Tristan?
Yeah, I would agree with the judge there in terms of parties. I will say the trickiest part, and I don't think we can get into that, and I'm actually in the middle of this, has prompted something for me. So Matt, I'm going to send you an email with an idea for a different project. But the hardest thing for me is if you have outside participants who aren't parties on either side, right? You don't really have anyone to sanction or anything else. And so I think there's probably nothing you can do. If someone is sitting at home, I think last time we discussed, you can disable the recording that Zoom itself or other programs can do. But if someone's sitting and wants to record it on their phone, probably nothing you can do. If it comes out and you've got a hook in them some way, right? And you can say, well, you can't participate in further proceedings or something else, then address that. But I think you're right, you can't otherwise, but I think that's probably pretty intractable. So just as it relates to the parties themselves, there certainly are, I think, consequences that you could lay out.
Well, I'm thinking of the non-parties.
Yeah, I think that's just hard to address.
And whether we want to say anything about it at all, or whether or not it's those sort of things. Well, you open this can of worms. What are you going to do about it? Or do we just keep it closed?
Renee?
So, we have a rule at my law school that students cannot make their own recordings of classes without the permission of the instructor. And all the classes are either have some Zoom component these days. Sorry that my email is beeping at you. And they are therefore recorded. And I don't know that the issue has ever come up. So, maybe this is one of these things that, the agency says what the general rules are, and, most people will probably follow it. And the only way it could matter is if somehow the official recording differed in some important way from the recording that the person made, so I don't know, I think maybe we shouldn't worry about it too much.
Judge McCarthy?
No, I think Russell makes a very good point that it's possible we're opening a can of worms by the phrase and whether they may record proceedings on their own. And I would leave things to the official recording, which is the decision of the adjudicator in consultation with the court reporter or the agency. So I think we may be opening a can of worms.
Tristan?
So if we were to pull that out, I know that was the suggestion from Russell initially, but if we just left it to access recordings of virtual hearings, I don't remember where we, again, last time kind of also touched on this. I think it was somewhere else in the recommendations, but I think if you just left it at that, access recordings, that's sufficient to imply that there's an authoritative recording, and that's, to me, that just, it's not worth the additional headache to mention the other piece.
Okay. Bill?
Well, don't you have to take out Roman 12 then too, whether participants may record proceedings? That raises the can of worms itself.
Tristan, did you have another thought? Or no, that's okay, that's fine. Any reaction to that, to just leaving this topic for someone to raise at the plenary? And we can say we discussed it. Annika? Annika?
Sorry, yeah, trying to get off
That's
mute
okay.
here.
No, I know, yeah.
So, having faced in the past an issue of, a litigant seeking to record and discovering that we in fact did not have rules that addressed recording, I am a little concerned with taking out the issue altogether. I totally agree with whether participants may record proceedings, maybe opening a can of worms, but we also want agencies to be aware that as they move to, or consider moving to a virtual hearing world, that they should be thinking about whether or not there are going to be additional, non-agency, non-record copies of these proceedings that, like Tristan said, could be manipulated or whatever. I want them to be thinking about that and not sort of have that, come after the fact when there are all these recordings out there, or things are being, filings are being submitted back to the agencies with audio snippets that aren't from the official record. It's just something to consider. So I wonder whether I know a lot of these start with whether, when, and how, and that kind of thing, but is there something that we can add that just says that agencies should consider issues regarding non-agency recording of hearings or something like that?
Hi.
So I agree that I think we have to say something. All right, let me just, okay, issues regarding, but I actually think a clearer way might be to just add interested persons on what had been 12, right? Because this is what we want them to think about for their guidelines. So whether participants or interested persons may record proceedings, and my guess, every agency is going to say, oh my God, no, and then they'll put it in. And then the last one is whether and how other persons can attend and then, or view streaming video. Not even access, because the access recordings is both participants and interested persons. So that can be your last one. And whether and how participants may access agency recordings of virtual hearings. I mean, those are your 3 points.
So
right?
you're saying that the access should be a separate, should be a whole new, a new point?
Yeah, I mean, the truth is, as we've said many times, there's already guidance on actual, in-person hearings. I'm sorry, take out agency, because depending on whether they decide they're going to let someone, but I think it is a last point. And by the way, they might want to have in their protocol and best practices whether you can record, and also put that in their standards of conduct, as someone just said, So I think it's the way we have it. And then I think it's the last one, whether and how participants or interested persons may access recordings of virtual
Would
hearings.
be a new point.
Yes, a new point after 217.
Yep.
Whether and how.
Because, whether and how they can access recordings. It's right, participants or interested
Or-
persons may access recordings of virtual hearings. And those are your 3 points, because 216 to 217 is about interested persons attending or viewing.
Does it add anything to say the official record? I don't know. I'm just trying to think of a way to. official-
Yeah, maybe official recordings. That's fine. I mean, the reason I took it out before is
Yeah.
beautiful.
something. Yeah.
Contained by the agency. Yes.
Okay. Any thoughts on this change?
Take out the "and" on line 215 and put it on 217.
Mhm.
Okay. Great. 7. I don't think I
Nope,
can't remember if we left off there.
Yep.
I'm sorry, Jeremy.
This is new.
Anything on 7? I'm seeing hands from Hi and Annika, but I think you guys are we good? Yes, okay. So facilities and equipment. Anything, we made that consistent with, sorry, I'm just looking at the changes that are here. We've used that simulates earlier, so now we're consistent. Let's start with Fred.
It may not be important for the agency space, but I did miss one small thing in the report, which is a suggestion that high quality bandwidth should be made available, which at home normally means cabled rather than Wi-Fi. In an agency space, there can be high quality Wi-Fi. It's not likely to take place at home. Whether it's worth including this or not, I leave to you and also to Jeremy's thought. It was just a small thing that I missed.
Okay, Judge Manuel.
Yes, the 8B, when I was reading that, I thought, this idea of having a couple of monitors or 3 monitors is a good idea. Typically, you could incorporate the idea there of court reporters, where if you could have one of the monitors maintain a split screen. I mean, maybe this is just too much kind of tech advice or suggestions to make, but if you have a split screen there, you'd be able to do readbacks. As you know, that happens all the time in virtually every hearing. And someone says, well, I didn't say that. And you ask the court reporter to read it back. So it's nice if you could have a monitor that facilitates that process.
I think that's a great point. It actually might be covered by this potentially a third for performing other tasks or accessing other information, which could be, as you're saying, a real-time transcript that's appearing. I think that's covered maybe by that point. Bill.
I was wondering why we needed desktop. I mean, laptop computers are pretty darn powerful these days. I just thought strike desktop and just leave it to a computer.
I bet Fred has a comment on that.
The problem with laptop computers, other than the fact that they're probably more expensive than the desktop, is the fact that at that point, most people are using the camera in the laptop, which means you're looking down. Now, you don't have to. and many of you are possibly using separate cameras. That was actually not something I had in my report, but in fact, you're probably going to get better technology from an inexpensive desktop, and you will be compelled at that point, almost certainly, to use a separate camera rather than relying on a very inferior laptop system.
Oh, I don't know. I'm still not convinced that you need to specify that it has to be a desktop.
So it would just say computer. Kent,
Small point, but one thing I was wondering with the line on A that says professional grade cameras and microphones, is it worth adding professional grade cameras, lighting, and microphones?
May I?
yes.
In a better world than we're living in, you'd be absolutely right. The problem is, especially with the use of the word professional, and it's not sure, Jeremy, whether it's the word professional, it's which one, dedicated maybe is the better word on that. Once we start adding lighting to the situation, people are going to think about whole room lighting systems, and that would become expensive and complicated, as distinguished from maybe, Jeremy just put in dedicated cameras and lighting. That works.
I think that's a good point. I mean, how often, I don't know, some of my Zoom calls with family can't see my mother because the lighting is so awful.
If you get a single circular light, a ring light, that probably solves the problem.
Right.
But again, Jeremy's use of the word dedicated solves that problem. If the word professional was in, we're in a whole different world.
I have to add a bit of levity here. I wish I had that problem because my mother doesn't even have a computer or a cell phone. So anyway.
I will gladly give my mother props. She's going to be 88 and she's figured it out. Just because of the pandemic, but it's all good. Okay, so any other adjustments to this paragraph 8? Excellent. 9. We have that change that we made consistent. Wonderful. Okay. Training and support. I think Jeff's comment was just a comment, right? He didn't have
Just a
anything
comment, yep.
specific. Yeah, okay. I wondered, and this may not be the spot, if the concerns raised by our New York group, the legal services and the center, I believe they raised some comments about accommodations. And I didn't know if this was the spot in terms of support to add something about that. I'm really just throwing that out there. I don't have anything specific in mind, so. I mean, to the extent that the recommendation is identifying individuals who may struggle with access.
Something about sort of building on technical support.
Maybe that's covered. And I, you know, agencies are already, at least mine has, I think there were some requirements to do so, established some language access plans to allow parties who appear before us to have full access to our hearings. And so to the extent we need translations, I think agencies are moving in that direction. That is one group that we have identified in our list of 3 earlier when we made those changes. I'm not sure what other I don't have the letter that we received in front of me. If there were other points that the comments raised about support or accommodation.
Just to mirror.
Oh, hi. Yes. Should've called.
The only thing I wanted to say, looking at the letter, is they said agencies have policies for providing reasonable accommodations as long as people know how to ask for those accommodations. That's all
Uh-huh.
that they said in
Okay.
the letter. A quick just, okay.
If you want to get at the point of providing tech support to participants during a hearing, which I think we sort of address providing guidelines about it, but here this would actually address the actual process for it. Something like this would just mimic the language in 11.
Mm-hmm. To the extent a participant needs an accommodation, I mean, I'm just spitballing this here. Agencies should I'm trying to think of, I'm really.
Proceeding.
Maybe it goes in guidelines. I don't, the idea that like you're saying, Hi, that they're aware they can ask, they're aware it's available and they can ask.
Right.
Maybe
So
this isn't the spot, but.
Yeah, I think, I don't think you need, I think up in the guidelines, we should, yeah, for pertaining to when and how did this? No, so I'm trying to think, you know what? I don't think so. I feel like the accommodation is back up when they say, I don't want to participate in a virtual hearing. And the guidelines generally say, if you meet ABC, we expect you to go virtual. The accommodation to that general agency policy is that that person doesn't. So I think, I think we should presume, again, I know this is so hard for us because we want to address everything, but really this is on top of everything agencies are already doing.
Yeah.
So I think we have it 181 to 183. I don't know if anywhere in the preamble.
No, I think you're right. I think you raise a good
fine.
point. And the language that you've pointed to, Jeremy, thank you for zeroing in on that. Okay.
Great.
So training and support, I think, are we done then? And then assessment, our last section. We can get this in under the wire. I know we can do it. Russell. Oh, Judge McCarthy, I'm sorry. Did you have something on the preceding section?
No, I don't want to slow us down, but let me just throw this out there. I thought Hi's point was who has the onus or burden? In other words, the agency should be doing this, but it's up to the participant who can't participate to request the accommodation. Is it not consistent with discrimination law? I thought that's where she was going, but I may be wrong.
Yes, of course, it's up to them to ask for it, but I think 181 to 183, that allows you to object or express concerns. Now, if you're a person with a disability who's expressing it because needing an accommodation, hopefully you're more likely to get a yes. But that's right. And what we're saying here is for people without disabilities, right? They don't have access, whatever it is. So I guess your point that they have to come forward to ask is absolutely correct. And I think what we have here will cover that.
Great. Thank you. Okay, back to assessment and continuing development. Bill?
I'm not sure what the words produce outcomes. I don't know what outcomes means here. How many people win? How many people lose? As many cases get processed? I just didn't know what produce outcomes meant in this context. maybe it could be more specific, or the person who put this in can explain what they mean.
Having been the person who put it in, this is copied from an earlier recommendation. That doesn't mean the committee is wedded to it, but that's why it's here.
And this has been a very important issue for ACUS in any debates about both video and virtual hearings. It's longstanding.
Yep.
I guess what does it mean, outcomes? What does it mean to produce an outcome that's comparable?
I think it refers mostly to the mass adjudication context, where you have similar to identical fact patterns. The only real difference between cases is the manner of appearance, and you have different outcomes on the merits. Is that attributable to the manner of participation? So this may be too specific to mass adjudication, and the earlier recommendations were certainly focused far more on mass adjudication.
And Jeremy, I guess I don't understand why it would be. I understand it's easier to quantitatively and empirically measure outcomes in the mass adjudication context, but it's not necessarily limited to that context. And I think kind of the larger principle here is one that's sort of very dear to federal rule writers and the federal courts, that, and I think it's reflected in the Rules Enabling Act, that, that procedural changes should not be outcome determinative in any way, in the sense that they should not, as the federal court rules writers would say, they do not affect substantive outcomes or the substantive rights of the parties. I think that concept is pretty well established. I don't know if it requires clarification here or elaboration.
I think
it is an important concept.
Okay, we'll go to Russell, and then Roxanne, and then Jack. And then I think.
Well, I raised it, and I'm second to none in my view that it's important that they be comparable. I was just trying to call attention to the methodological problems of doing it. And I mean, if I had my druthers, I'd just take the first sentence out or replace it with something like, I'm just off the top of my head, agencies should recognize how important it is that litigants are treated equally in regardless of the format, or something like that, but then recognize that that's no easy task. It's really difficult to control for all the variables. It's often said in the immigration context, when you look at the scandal of lack of representation of respondents, and it is a national scandal, but when you say, well, if a lawyer is present, they're more likely to avoid removal. Well, part of the reason for that is if the lawyer's present is probably because they figure this is a case they can win and it's worth their scarce resources. So I offer that just as an example of the difficulty of just assuming that you can easily analyze different procedures in different formats and conclude that they are or are not equal. And so what I was trying to do here was just suggest that, you take a step towards it. These are ways to do it. But then that next sentence I suggested inserting is just a warning that it's a difficult thing to do. Now that may run into longstanding ACUS policy, and I don't want to intrude on that. But when I read that, it just struck me, whoa, you're getting into the deep weeds here.
Well, I think, Jeremy, were you trying to point out that some of the language that's in the document here is echoing something that was said earlier?
Last time we had debated the term outcomes and had qualified it by saying procedural fairness or substantive outcomes to sort of qualify what we mean by outcomes. I don't know if that's a useful distinction here, but I throw it out there for the committee.
But it is already in the recommendation and language we've approved.
Yes.
We've not approved, but gone through and okay. So I think Roxanne had something, so I want to go to her first.
My question was actually going to be aimed at the first sentence, and so Russell's suggestion to take out the first sentence, great, then I don't have to ask that question. I think that including this section in is good, because as we all know from employment discrimination law, you can have different treatment where you purposely take steps that treat people differently, or you can have different outcomes, which you maybe don't or different impacts, I should say. You didn't intend to treat people differently, you just accidentally did somehow. So you need to assess that and make sure you're not doing it. And I would view this along the lines of the latter, where you're making sure that while you intended everything to be the same, when you look at perhaps your merit findings in traditional hearings and your merit findings in a group of virtual hearings, hopefully you should come out about the same.
Thank you. Okay, Jack next, and then Renee.
Yeah, just really quickly, I feel a little queasy about this only because it might be that virtual hearings would be better, would produce better outcomes than in-person hearings. And in fact, I think a virtual hearing with no camera so that the decision maker couldn't see the person and might be superior to any other sort of hearing. Credibility determinations, research shows they're just not reliable at all, that a computer would do a better job deciding most things that turn on credibility than a living judge. So I just want to, I guess I just want to register a general discomfort with the notion that we care whether the results are comparable. They could be better.
Okay, Renee.
What I hear what people are saying about outcomes, but we're talking about outcomes in the experience of it. You know, do people experience the hearing as, you know, meeting all the, you know, the things that we would think would be important, that, you know, they had the opportunity to say their piece, that they were listened to, they were respected, you know, all those sorts of things. And so I guess I would like to get into this somehow, the experience, you know, how people experience the hearings, recognizing that it cannot be the same, you know, right, as the in-person experience.
Isn't that paragraph 14?
Yeah.
I think that
Yeah.
touches on getting feedback on that. Yes.
Yeah, but I think, what are we getting? Satisfaction with, you know, I would add with the experience, with the virtual hearing experience. So, you know, maybe in 14. All right, so.
I mean, there could be a way to combine 13 and 14.
Right.
Judge McCarthy, did you have any thoughts on that?
Well, I was going to reiterate what Jeremy said. My recollection is we use the word outcome in recommendation 1A, and I don't have the revised version in front of me, so I wondered what 1A said with regard to this.
It's on your screen there.
Yep.
Procedural fairness or substantive outcome of cases heard by agency. Okay, thank you. Because we did have this discussion last time.
We did.
So maybe affects procedural fairness or substantive outcomes, then it's the same parallel language.
I think we should use the same language. Hi, did you have an additional thought here?
Yeah, I was going to say, in terms of assessment, given that this was 1A, we absolutely need to say that agencies should try to measure it, right? Including if it turns out that video is better. Let's know that. I was struck by the fact that it's through the use of participant satisfaction scales and other instruments, as opposed to let's look at the outcomes. Did that person win their employment claim or not? But you know, I should try to measure whether their use of alternating hearing formats affects procedural fairness. And by saying should try to measure, we are acknowledging, as Russell said, this is not easy, but right under assessment, try to measure, you know, and recognize the methodological challenges in assessing whether it prefers go down. Okay, no, and then I don't think you need the participant survey, because then, because
you have it in 14.
You have it in 14, and you're not getting through a participant survey whether they felt the substantive outcome was right. You know, but per Renee's point, maybe in 254, to determine participant satisfaction with the virtual format and identify any problematic issues, you know. Again,
so you would add with.
Right, with the virtual format, because they're not going to be satisfied with the outcome if they lost. virtual
Mhm.
format and identify any concerns. Let them
Mhm.
raise some concerns.
Mhm. Okay.
Okay, I'm not sure what the new second sentence then adds, that 255 to 257.
Russell, I think that was from you.
255 to 257.
Yep.
Yeah. Yeah, I just thought it was an obvious statement.
But maybe it's covered by the first sentence of 14, 253 to 255. Is that what?
Exactly.
Yeah.
That was my point, that
Well,
it's covered.
it's one thing just to find out whether they're happy with it. Is also, here you're talking about comparative measures. So I think it's important, but I'm not going to push the point. I don't think it would hurt to keep both, but so be it.
What is the difference?
Russell, are you saying the first part is to collect the raw data and the second part is actually doing something with the data?
Well, one tells you just whether they're satisfied. You want to know that, we're not satisfied with the chairs are too soft, that kind of thing. The other thing can also help you in these comparative measures, which is methodologically more complicated, but it's obviously one measure, one instrument to use or one variable to measure in a comparative sense. That's the reason I think I'd keep them both, because they're serving two purposes.
Does it need to be phrased in a way that's pointed to the agency? It's more of just a statement right now of what's possible as opposed to an action, right?
Okay, yeah.
Agencies can use this feedback, or well,
Agencies should
Right.
use this feedback to assess. I don't know, it just seems like we always say agencies should. Jack, did you have a comment here? Language to propose?
I have something on the previous thing, one word, but I'll wait.
So maybe it just solved by saying in the first sentence should collect and no, collect and use. I was gonna say collect and use. I
what
don't
is it,
think we-
determine and analyze, or take the verb assess from here and
Move it.
does that get you there?
Yeah, maybe. Does that replace the second sentence?
Yeah.
Because I think we have it all in the first sentence.
Yeah, I think,
Okay,
it can go out.
okay. Jack, do you want to raise your one word in 13?
Yeah, I just recommend putting after the word or, fairness or substantive outcomes, put the word produces, because otherwise effects is the wrong effects. Or the word produces
Right here.
before the word substantive, just before the
yeah.
word substantive.
Got it.
Yeah.
Okay.
Did you want that in 1A too, or don't worry about it?
If it's the exact same sentence, it ought to be changed because it doesn't work as a sentence.
Great. So without affecting the procedural fairness, or well, actually, no, there it's okay.
Yeah, I
there
think
it's fine.
there.
'Cause
It's fine.
Yep.
Renee?
This is more of an observation or a comment on what we were just talking about in 13 and 14. So, healthcare is sort of what I do, healthcare law. And this whole discussion is about patient satisfaction surveys, right? Healthcare organizations do these patient satisfaction organizations. Your health plan tortures you with these questionnaires every time you go to the doctor, all of that stuff. But it's, and it's different than the substantive outcome, right? It's really about, did the doctor keep you waiting for 2 hours when you were supposed to be at work? Were they rude to you? All that kind of stuff. And so I think that we have to tease apart and evaluate both aspects of this issue, and not just this, the substantive outcome, which is not necessarily subject to the patient's interpretation, but subject to, some kind of professional evaluation, like it would be in medicine. And so I don't know, maybe thinking about how we measure these things. I don't know, does ACUS have anything about that, or best practices or survey tools that could be used? I mean, that might be another next step in this whole process that would be applied to in-person hearings as well as to the virtual hearing process.
Yeah, or any number of adjudicative services.
Right, yeah. That might be bigger than this,
That might be a new
right?
project.
That might be a new project.
Yeah,
Thank you, Renee.
absolutely. A good one. Yeah.
Yeah. Okay, I think we're good on 13 and 14 unless I hear somebody say otherwise. And then 15, we're reconciling, we're using the same sort of try to that we have in 13. And I'm not sure we have much else. So is there anything further on 15 or 16? Is that actually the end?
That's the end.
My goodness. And we have 9 minutes. Wonderful. Okay. So there are a few spots where we have to do some more massaging. Is that the right word there, Jeremy?
That's the right word.
My thinking on this would be, and we've done this before with this committee, rather than have a firm meeting, we have a tentative meeting date of Friday, May 14th. It would be great, since we have some cleanup work that we can do to this, if we could take some time to let Jeremy work his magic and make sure things are where we leave them as of today. And then they can circulate the draft to the committee by email. Everyone can take a look and hopefully vote on it by email. If we need to, if we feel that there's further discussion, we need to hash some additional points out, we can do that. We have that meeting date, Friday, May 14th. Is there any thoughts, objections to handling it that way? As I said, we have done it that way in the past, where it's circulated to the committee and reviewed and then weigh in by email. Put a little pin. Preferable, according to Russell. Great. Anybody else?
Yeah, you did send it to committee members, and I'm not a committee member. But otherwise, if you send it to me, I agree that's a good way to do it.
I think we can do that.
We can do that.
I apologize. So we will look for that email and respond as quickly as we can. And if we don't need to meet, then we will be all set and ready for the plenary. Anything else I need to cover on that, Jeremy?
I don't believe so. I think that's it.
Fantastic. This is great. This is great work. I learn something every time I do these meetings, and it's a great group. You all come to play. And
thank you, Nadine. You've done a fantastic job. So
thank you, Bill.
Really appreciate it.
Ditto.
Ditto.
Thanks. Team effort. So with that, I can give you 5 minutes back of your afternoon. Start your happy hour early. And it's great to see everybody someday soon, hopefully in person.
Thank you, Nadine.
Thanks so much.
Thank you.
Thank you.
Bye.
Bye-bye.
Say, Jeremy, do you have just a second?
I do.
So can you put that document back up really quick? Because I think I had a suggestion for one of the things that we'd moved past. And I didn't want to drag everybody back to, for you to give some thought to when you're trying to clean it up.
Yep.
Where we are right now, number
Okay.
2, it
Great.
says agencies should determine, and then we put a bracket. We said if any do, make corresponding rules. I thought you might be able to incorporate it all in one sentence if you said agencies should, I'm just thinking out loud here, but agencies should determine whether any provision of their rules of practice should be revised to not unintentionally restrict adjudicators discretion, blah, 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 because that's where we're trying to get to is
Yeah,
what will we do? So what you're looking for is, do we need to make any changes because
Right.
we are unintentionally restricting? So then you can, but anyway, I just thought that might be a way to do it.
Yeah,
Sure.
that's perfect. No, I appreciate that. That's great.
Okay. All
Feel
right.
better. Thank you, Roxanne.
Thanks. Bye-bye.
Bye.